Hello and good evening, everyone. Thank you for joining us for this evening's webinar, Estate Planning for Artists. My name is Diana Cervera, and I am the Director of Education with California Lawyers for the Arts. I'm very excited about today's topic, and I know that there are a lot of artists, freelancers, and arts administrators in our audience this evening. For those of you who are joining us for the first time, welcome. I would like to share a bit about California Lawyers for the Arts and some of the benefits of joining our organization as a member. CLA is a statewide nonprofit organization serving the arts community by providing a number of legal and educational services across the state. These services include educational webinars like this one, legal clinics, symposia, and a lawyer referral and information service, which helps to provide accessible legal support to the arts community. Membership with California Lawyers for the Arts allows you to save up to 50% on educational programs, $15 off of every legal referral fee, and will allow you to enjoy discounts on our video on demand library of workshops and MCLE programs. You'll also have access to free recorded workshops in our foundational series on fundamental intellectual property topics. Please feel free to follow us on the social media platform of your preference to keep up to date with our programmatic offerings across the state. With your support, California Lawyers for the Arts continues to provide critically needed legal support for artists and arts organizations throughout California. And now, without further ado, I'd like to invite Keith Denny, who is our speaker for this evening, to join us on camera while I read a bit of an introduction for you. With nearly 30 years of legal experience, Keith Denny does estate planning in Southern California with a subspecialty in estate planning for artists. A writer, as well as a lawyer, he can help creative people bridge the gap to the complicated world and language of estate planning because he goes over that bridge every day. Keith, thank you so much for being here with us this evening. We're looking forward to your presentation. Please feel free to share your screen and tell us a little bit more about yourself or anything else you'd like us to know.
Thanks very much, Deanna, and thank you to California Lawyers for the Arts for hosting and making this webinar happen, and thanks to everybody that's joining us here today. And that's some contact info for me. If you have any follow-up questions, there's stuff that it's either too detailed or too time-consuming to get into in this format. Feel free to follow up with me if you have something like that in mind. Let me just say that I'm very grateful to be asked to give this webinar, and for a lot of reasons, but the big one is it combines two of the 4 or 5 things in this world that I most enjoy, and that's art and estate planning. As Deanna mentioned, I make that journey between those two things every day. Art, sort of in the broader sense of aesthetic endeavor. Since I'm a writer, I've been fiddling around with the written word just about since the time I was old enough to figure out what to do with a pen and a piece of paper. The course of my life led me to be friends with artists, a lot of other people too, but the artists always seemed to be pretty much the most interesting friends. And once I became a lawyer, eventually I wound up helping them, having the privilege to be asked to help them with their estate planning needs. There's the two things in the world I like as well as just about anything, estate planning and art, and those are the two things we're going to talk about here tonight. And even though it seems like we should possibly start with art, I'd like to start with estate planning. And that's because what I want to do is explain some of the estate planning challenges that artists in particular are going to face. And to explain that, I need to have you be able to understand just a little bit. I mean, there are books and books and books and books written about this stuff, but I'm going to give you just the nutshell of a few things so that when we get to the part about how it relates to artists, you'll know what the it part of how it relates to artists is. Let me just start with a couple of very basic estate planning terms, and they are probably terms that you've heard and you have at least some idea what these terms mean, what a trust is, what a will is. I'm going to start with a will. A will is a very basic thing. It's writing down what you want to have happen to your stuff after you're gone. The thing about a will is that it's sort of a fundamental thing. It's your stuff. I mean, you worked hard and you saved for decades to accumulate what it is you have to pass on to your heirs, your children, your relatives, your friends, any charitable purposes that you have. You should be able to control what happens with that stuff after you pass. That just seems right. Well, a will is the most basic basic way of writing down what it is you want to have happen with your stuff after you pass. Now, the trust is really the crux of what I think of as modern estate planning. And there's a reason for that. A trust operates with sort of an idea about ownership that I need to explain to you just a little bit. When you own something, you own a baseball, you own a car, you own a house, you don't much think about ownership. You think it's mine, I own it, I have it, it's mine. But in the law, and I mean going back hundreds of years, there's a duality of ownership. There's two kinds of ownership. One is called equitable ownership and one is called legal ownership. These terms float around a little depending on what book you happen to be reading, but the basic split is between equitable ownership and legal ownership. The legal ownership is the kind of ownership you usually think of. I have it. I get to do with it what I want. I get to enjoy it. I get to use it. That's essentially legal ownership. Equitable ownership refers more to the legal title to the thing that's being owned. It's a little easier to think of in terms of a house. With a house, there's deeds and there's a title and it's recorded and it's an official record. That's kind of the equivalent of equitable ownership. Whereas the legal ownership is you get to go to the house and it's yours and you get to do with it what you need to or what you want to. One analogy that kind of draws out this kind of split in ownership is to think of a rental property. Technically, the landlord owns the rental property, but the tenant has the right to use it, enjoy it, go there, do what he, she, or they want. So that helps illustrate the difference between legal and technical ownership. Why did I want to explain that to you before I told you about the trust and what I call the magic of the trust? What a trust does is to take advantage of that split in the types of ownership. So that when you have a trust and things are done properly, the technical, equitable ownership of the property is in the trust. This gives you a really neat advantage over just having a will, particularly for property where there's a legal title, where the property is held in somebody's name, real estate, cars, brokerage accounts, bank accounts, certain kinds of equities. These things are owned by some person or entity in their name. When you have a will, you're halfway there because the will is now a writing that says, I want this to go to this person, I want that to go to that person, I want these things split equally among these people. You're halfway there because any of that stuff that is held by title, that is owned in somebody's name, like real estate, like various kinds of accounts, like automobiles, if you pass and you have only a will, the only way to change the name of who owns that stuff is to get an order from a court. The only way to do it is to get an order from a court. Now, that's not a big term, to get an order from a court. It doesn't take that long to say. There's not that many words or letters in it, but it encompasses years, 2, 3, 4, depending on the size of the estate, the complexity, and how backed up that particular court is. It takes years and it costs tens of thousands of dollars of money that at one point you thought you were just going to be leaving to your heirs. So the magic of the trust is already the equitable owner, the technical owner of the property. When you pass, you don't have to go get an order from a court to change the title. The trust already owns it, and the trust will have instructions on who gets what. And the trust can just sign deeds, sign transfers, sign assignments, whatever the particular document is for that type of property, and transfer that property to the people that you wanted to get it. And that's the magic of the trust. You don't have to spend years and tens of thousands of dollars, and it can be more, to get the property given to the people you want to receive it. Let me mention something here that it applies to artists, not particularly to artists. It kind of applies to everybody, but anybody with children, this is a concern, and I've seen people a little surprised when they find this out. Let's say there's a couple, they have children. Worst case scenario, the couple is out driving, there's a car wreck, they're both gone. The children's parents are both gone. A lot of people think that there is this thing called godparents. And well, they're right. There is a thing called godparents. And the thought is that, okay, the godparents automatically get custody of the children. Well, you remember how in the magic of the trust, if you don't have the trust, then you have to get an order from a court to transfer the property. Well, kids are a lot more important than property, and you can't put kids in a trust. You do have to get an order from a court. And yes, people who know what the parents thought about who should be the godparents can go and testify, can tell the court about that. And this is something I say to people, but what's really going to impress a judge a lot more than some people say, oh yeah, right, godparents were so-and-so. And what's really going to get a court's attention is if you have a section in a trust, could be in a will, but a trust is obviously the magic part of the estate planning equation, my opinion anyway. And that section says, if there's a worst case scenario, this is who we nominate to be the guardians of our children. And this is in a writing that you signed, you dated, it was notarized, maybe there were witnesses. That's going to carry some weight with a court. That is, again, not particular to artists, but there are plenty of artists with children, and this is an important part of estate planning. So just to recap this part real quick, a will, basic writing about what you want to be done with your stuff after you pass. A trust is a document that takes advantage of the difference between legal ownership and equitable ownership to be able to transfer the property after you pass without any need for going to probate and spending time and money trying to get a judge's order. So let's take that and plug that into some of the concerns and challenges that artists in particular are going to have. So the first term you'll see there on the slide is works. So when I say works, what I mean is paintings, it could be photographs, it could be pieces of sculpture, it could be literary works, manuscripts. Basically, we're talking about works as being any aesthetic endeavor fixed in a tangible medium. It's not my word, it's actually pretty much straight out of copyright law. So the works that an artist has are his or her, their paintings, their photographs, their sculptures, their manuscripts, whatever other medium they might work in. Now, the interesting thing here, at least I find it interesting, the artists I know, pretty much every one of them, at least the ones who paint, they have a back room, a family room, sometimes both, filled with works, with painting after painting, dozens, maybe 100 canvases there. And what happens over time seems to be that there get to be more instead of fewer. If you play that out over time, when the artist gets to the end, there's going to be a lot of works. And this is where an artist's estate, and so by estate, we mean the stuff you leave behind. In this case, part of the artist's estate is dozens, maybe dozens and dozens of works. And there's this truism that I think is probably at least occasionally true, and that is that there tends to be an increase in the interest in an artist's works after they pass. So one of the first things that needs to be done with respect to an artist's estate, the administration of an artist's estate, is to notify collectors and galleries that are already respectively buying and selling the artist's works. When I work with my artists on this, I put a schedule, which is basically a list at the end of the trust, and I just say, these are the galleries and the collectors that should be notified after I pass. One of the things, in addition to notifying galleries and collectors, is there's a lot of social media, there's a lot of channels of communication concerned with artists and collectors, and what you want to do, what someone administering an artist's estate wants to do, is to get the word out through these channels as well as to the galleries and the collectors and tell them, hey, this artist has passed, there's still works to be had, but they are as of now on limited supply. So this I refer to on the slide as curation of interest. One of the things you want to do is make sure people are on notice, that they're hearing about it, that they know the opportunity is there. So I'll get to licensing in just a second. I'm going to kind of skip these bullet points here, that one anyway. and talk about inventory, etc. So you're busy curating interest. You're letting collectors, you're letting galleries, you're letting any kind of informational channels, any kind of media that are relevant know that, hey, we've got these works. This is all these are all there are. This is going to hopefully result in sales of the works. So in order to make that work, the first thing we have to do is know how many there are, what they are. We have to make an inventory. We have to make an inventory of the works. There's 48 paintings, and they're these sizes and they're these titles. There's 27 statues. They're these sizes and they're these titles. We're gonna want to start with an inventory. Now, storage. Well, if you remember the example of the artist that has them in the spare bedroom, in a back room, in even sometimes the living room, and they pass on. So what happens to the house? Almost invariably, way over 80% of the time, that house is going to be sold. So you can't keep the works there anymore. You've got to arrange for storage. The storage should be, weatherproof, dry, climate controlled. There's a lot of things that go into it and secure, but there's got to be some kind of storage, and that has to be taken care of. Now, if you're selling the works, there's the whole paradigm of shipping them. I've talked to people who will never use UPS again, and I've talked to people that will never use FedEx again. Different people have different feelings about how they want their things shipped, and artists are no exception. This can all be written down, but we have to think about that when we're thinking about an artist's estate plan. And shipping isn't just a one-word thing. Shipping means you've got to pack it. You've got to insure it. You've got to track it. You've got to collect for it. And now that you have money coming in, by the way, there's all kind of other stuff you got to do. And this is something that happens in just about every trust administration. And so it's something that, trusts are particularly well adapted to. And that is suddenly you've got to do bookkeeping type things and accounting type things. There's going to have to be tax forms prepared at some point. So there's a whole menu of things that go along with shipping and collecting the money. Let's skip back up now to licensing. Licensing, you can have at least for visual art, you can have your works printed onto sheets, shower curtains, bed covers, shirts. And if there's a market for that, that's going to provide a revenue stream that might well produce a revenue stream that goes on for years after the last one of the works is sold. So what happens is you've got a variety of tasks that are particular to the estates of artists that trusts are particularly well suited to handling. The basic top line here is that trusts are exceptionally well suited to an artist's estate plan. In fact, everybody should have a trust because the magic of the trust. You avoid years and tens of thousands of dollars in probate, and that's just plain a good thing, number one. Number two, if you're an artist, you should really have a trust because these kind of tasks that are going to have to be done that include everything from physically moving things around to the details of accounting, these are all tasks that trusts are particularly well suited to handling. When you're talking about estate planning for artists, all roads lead to trusts. I'm going to touch now on just a couple of related things, one squarely on topic, one a little off topic, but these are concerns I've had clients raise with me in the context of estate planning. So it seems like a good idea to just touch on them real quick here. So the first one is LLCs. And what I mean by that is some artists, we may have some here, I don't know, have personal corporations or LLCs, subchapter S creatures, which they have assigned the rights to their works to these corporate entities. And there's a lot of reasons to do this, but when you get to the estate planning side, and I'm not going to get too wonky on you, I hope I haven't. But to put it real succinctly, corporations get taxed at a much lower rate than trusts. Trusts get taxed around 38% on their income. I mean, it's a big tax. Now, a trust, in terms of its income tax accounting, gets a credit against its income for any money it distributes. So in other words, you're selling the works and money is coming in for the works, and you're giving all the money to the heirs, the children, the grandchildren, whatever the beneficiaries of your trust are. And as long as the trust is distributing as much money as it's getting in, it's not going to have that income tax problem. Now, if you've got something like licensing fees that are coming in for a long time, if you've got a lot of works and it's going to take a few years to sell them all and to successfully curate interest in them and get them sold and shipped and everything else, this means you're going to have to run the trust for a few years. And what this means in turn is that you're going to need money to keep running the trust. You're basically running a business with trust. And to run a business, as I have a sneaking hunch everybody here knows, run any business costs some money. So it's going to be tough for the trust to do that if it's giving all its money away. If the trust owns an LLC and the LLC has the rights, the LLC can retain enough of the earnings to keep running that business and then distribute the rest to the trust, which can then distribute that portion of the earnings to the beneficiaries, and you don't quite have that tax issue. And so one of the phrases in there is, if the trust is running the business. Well, that's where the idea that maybe I want an LLC, maybe I want a personal corporation comes in, because you are running a business. You might as well have a business to do it, particularly if it's going to make your tax life easier. Now, I'm not giving tax advice, and this tiny a sliver of a very big topic. There are, lineal shelf feet of IRS regulations and lineal shelf yards of books explaining and interpreting those regulations. So this is just like a 5,000-foot view, but this is one of the things that comes up in a comprehensive estate plan, and it has sort of particular application to artists, because artists, some people have businesses, and so their trusts and their estates are going to have this issue of running a business and needing to retain some money to run the business. But it's also an issue peculiar to artists. The second issue is foundations. And foundations, I get asked, well, Keith, shouldn't I start a foundation? Just do that. Well, you can do that. And you can even find websites that say, oh, it's easy, it's cheap. The reality is that there's a place and a use for foundations, and it's kind of a narrow thing. First of all, it's really something for high net worth folks, because remember, we're talking just a few minutes ago about how it is that a trust is running a business and needs to retain some of the earnings in order to keep running the business. Well, if you're going to keep running a foundation, you're going to need money for that too. And there's rules about, how aggressively you should be investing the money that a given foundation has. And by the way, most foundations, not all of them, are supposed to give away about 5% a year of their principal, not their income, their principal. So now you've got to cover operating expenses and give away 5% a year, and somehow not run out of money. You're talking about needing a lot of money to start with. That's one of the things about a foundation. They're complicated. They cost a lot more to put together, and they do have to have a charitable purpose. Now that can be giving out scholarships to art school. And if you've been that successful and that's something that you want to pursue, it can be done. I'm just saying that it's not for everybody. A trust is for everybody. The trust is for everybody because, number one, the magic of the trust to get through probate. Number two, for artists, it's extra magic because it is an ideal vehicle to handle the concerns and challenges that are peculiar to the estates of artists. And I think with that, I want to thank you for listening, attending, and I'll turn it back over to Deanna for any Q&As that we have.
Thank you so much, Keith, for your presentation. I have a question that we can start with, Keith. When should folks start thinking about either starting a trust or writing their will? When do you advise is a good time to start putting in some of those things in motion?
Well, it's interesting. It's a really good question. I have seen estate planning sort of evolve from something where the clients that I saw are in their 50s, in their 60s, in their 70s to clients in their 20s and 30s and 40s. There's a lot more awareness around kind of the advantages of trust and even wider understanding that if you don't have something in place, the state has some rules that say, okay, give it to these people. And that may or may not be who you want to get it. And by the way, even though the state has those rules in place, it's going to take time and cost money to go through probate court to get the order to get that done. So there's sort of a lot more awareness I'm seeing filter down into younger folks these days on the topic of when's the last moment at which you should do it. My personal opinion, when you have a child, even when you're expecting, because once you have a child, you'll be a little busy. And when you buy a home, even just a condo, as soon as you've got real property or children or both, it's time to get an estate plan in place.
Perfect. Any recommendations on handling copyrights?
That's a really good question also. And I kind of just brushed along the edges of that when I said some of the works might be literary works. Well, what that really means is some of the works might be the copyrights held by the artist, the writer, in those literary works. The way in particular that would work, let's say you've got a trust, you're getting a trust, you're having one put together, and you want it to hold the copyrights. It's fairly a simple form. It's 2 or 3 paragraph legal form that is just called an assignment of rights. You can assign the rights to visual works. You can assign the copyrights to literary works. You can assign those to the trust so that the trust holds them. You can also, if you're thinking, okay, maybe I will have a corporation as part of this plan, then you can assign those rights to the corporation. And a lot of artists, a lot of people I talk to, they're a little hesitant to start up a corporation while they're still alive, but you can set it up so that the trust can create the corporation and transfer the rights. You have to have that first transfer in place where you transfer those rights to the trust.
My husband and I already have a trust for my kids, but not for my artwork. How do I incorporate my artwork into the trust? I am also not sure I want to give my kids the responsibility of my artwork, and they don't have the expertise. So should I look to other folks in my life that are experts?
Really, really good question. We're getting some really good questions here. Basically, I'll start by touching on what we just talked about. You can assign the rights to those works or assign the copyrights to the trust so that the trust owns them. That's a first step that you should take. Then the second step, I have seen artists get professional trustees, professional fiduciaries. There are folks whose business, and they're licensed and bonded and insured, and their business is basically to be trustees. Their business is to administer trusts after folks pass away. Some of them are going to have some experience doing that for artists, some not so much. Now, one thing to think about, and it's going to kind of depend, is going to kind of be very individual, but if you're friends with other artists and you have one of your artist friends that you think might do a good job of it, you might talk with them. Now, there's a lot of considerations, like is there a difference in age, or are you both likely to be climbing that ladder at about the same time? And the other end of it is, do you know for sure that the kids aren't going to be able to do it? Maybe that's not them. Or maybe it's just a matter of right now they're too young. But if God willing, enough time goes by, kids, they learn, they get smarter. Adults, they learn, they get smarter. And there may be the possibility that they're going to come around and be really quite capable of it. If you're going to do any of this, so if you're going to say, get a professional fiduciary to be the trustee, if you're going to ask a friend who you think has the capability, if you're going to do that and then go back and say, you know what, 20 years have gone by, the kids are sharper than anything, and I'm going to have them do it. You can, unless somebody puts you in an irrevocable trust, which is a very unusual thing, and it's also a very high net worth people thing, my opinion, you're going to be able to go ahead and amend the trust. So once you kind of sort out the logistics of how you want to handle that, you're going to need to talk to, if you already have a trust, your trust lawyer, someone like myself, someone who is a trust lawyer who knows trust, and ask them, can I do an amendment to this trust? And this is what I want to change. And that's not a problem. It's a very routine thing. In fact, I've handled estates where there were like 5 and 6 amendments to the trust. So that's not something to be afraid of.
Perfect. And there's just a few more questions before we wrap up. What is the best way to distribute art to family and friends? By lottery?
I don't know if that's best. You can do it. I haven't seen that done. There's 2 basic things I've seen. One is, I want Summer Breeze to go to Bob, and I want Spring River to go to Donna. And I want Winter Freeze to go to Michelle, to specifically say who you want to get which work. You'll see this in estate plans with things like jewelry or particular kind of keepsakes that some family members always had a fondness for, and you want them to get it. There's ways of putting this into the estate plan. I want so-and-so to get this. I want so-and-so to get that. The other is you can do it a couple of different ways. You can just say, and I want all the works to be divided among the family members fairly, equally, whatever. That's a little complicated because if it's not your specific wishes, like let's say Autumn Breeze is worth 10 times as much as Winter Freeze, but it's your wishes and that's how you want it. Okay, no problem. But if you're just going to say, and everybody gets to pick a few paintings, the trustee is responsible for making the money on that come out about equal. So that's going to mean, okay, now we got to appraise everything and we got to do a lot of math. And then we might have to offset some of the other distributions from the estate to make it all come out even. Whereas if you said, I want, these works to go to these people and without offset, magic words, and that makes that simpler. So those are the 2 things I've seen, specific and just kind of what I call free-for-all. Lottery, you could do that, but I think you'd probably still have the equal value thing going on unless you say do it by lottery and without offset.
Great.
What are the logistics of forming the trust? Who gets a copy of it to know how to move it forward when you don't have any living heirs and no children?
Okay, good question. First of all, your attorney should get a copy. In that particular case, it's not that big a deal, but it's handy for there to be someone neutral and impartial that has an official copy. And so that, most families get along very well. And it's a tough time when somebody dies and they pull together. There are some families where that's not the case, unfortunately, and claims and counterclaims and this and the that start. It's handy to have someone neutral that has an official copy that hasn't been fussed with. So in terms of if you don't have heirs and you don't have family members, relatives you want to make a gift of your estate to, really the next thing that most folks look at is charities. I mean, maybe you're a cat person and you want it to go to a particular cat sanctuary, or, maybe the happiest moments in your life were at the wild animal park and you want to see if they have a foundation that can accept donations. There's sort of something to suit every interest in terms of charitable vehicles for you to gift your estate to.
Perfect. And I think this is a great one to wrap with. So for artists that are constantly creating new works, maybe in different mediums through different decades, when do you recommend and how often should the inventory in the trust be updated?
Great question. Frankly, I'd do it yearly. And when I put the trust together, if I was working with this artist or an artist like this, I would say, this is where I keep my works. I'm going to update this yearly, but there may be several months of new works in these locations where I keep them that are not here inventory. The trustee should check for that.
Perfect. Great, Keith. I don't know if you want to leave us with any final thoughts. I thought that you made this topic that I think, like you said, could be a little bit like murky to navigate if you've never thought about this or haven't started thinking about it. I don't think we've covered this topic in a while, so I think it's really a great thing for artists to think about as we're building our legacies, as we're building our, body of work and kind of like what happens after. So yeah, any final thoughts from you and we can wrap there.
First of all, thank you again. Thank the organization again. Thank everybody who is joined us again. But just to reiterate the top line, everybody should have a trust, and doubly so artists. Trusts are pretty much the perfect thing to handle an artist's estate.
Thank you so much, Keith.